Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's case, we have one that might be thought of as being at least partially inspired by the show Pawn Stars, because we have to figure out, what is this bar of gold worth? Let me call in an expert. I have to get it framed and make it look really nice. Is it $550,000? Is it $100,000? Who knows? Well, who has to figure it out in this case is a jury. This brings us to United States of America versus Jared Alexander Goldman. In this case, Mr. Goldman stole a gold bar, and we have to figure out what it's worth as part of restitution. So let's figure out what this gold bar is worth. Let's get started with this. This is the tale of a gold bar known as Gold Bar number 27. And we pick up the story in 1622. A Spanish fleet of ships sail from Spain to various parts of America to pick up gold, silver, tobacco, copper, and other goods to take back to Spain. As they obtained their cargo, the ships convened in Havana, Cuba. Among these ships was the Santa Margarita, which carried Gold Bar number 27. Unfortunately, without the benefit of modern technology, the ships left Havana on September the 4th of 1622, smack in the thick of hurricane season. And sure enough, within 24 hours of the fleet's departure, a hurricane descended upon the vessels. 7 of the ships sank in the waters between Cuba and the Florida Keys, or smashed upon the reefs of the Florida Keys. Among these were the Atoka and the Santa Margarita. So Gold Bar number 27, on board the sunken Santa Margarita, sat on the bottom of the ocean for hundreds of years. Unfortunate for us, this gold bar, St. Margarita, did not go well, and is now sitting on the bottom of the ocean. From 1622 until an intervening event in 1969. So in 1969, Fisher and his team began searching the waters of Florida Keys for the Atoka. While they were searching for the cargo of that vessel in 1980, they came upon Santa Margarita's wreckage site. Fisher and his team recovered from that wreck, among other items, gold ingots, including Gold Bar number 27. To promote interest in the maritime history of Florida and the Caribbean, Fisher founded a museum in the nearby Key West. And as noted, Fisher donated the museum the item treasure salvors inventoried as bar number 27 from the Santa Margarita. So this gold bar has gone through an interesting and rich life. This gold bar has been made in the Caribbean somewhere, and is being brought back by Spain to Spain. And unfortunately, the ship it was carrying on had some trouble, and it sunk. No word of what happened to its crew, but as to Gold Bar number 27, it sat on the bottom of the ocean for the next 300 years. And then this guy finds it, and among other things, and he says, I want to promote interest in the history of the Caribbean, and I'm going to start a museum. And in this museum, I'm going to put Gold Bar number 27. So, unlike Indiana Jones, Gold Bar number 27 really is going to a museum. All right, so what happens next? At this museum, Gold Bar number 27 lived its best life. Gotta live that good life, yo, and that's where it's going to happen at the museum. It became the focus of the museum's Lift a Gold Bar exhibit. The exhibit allowed visitors to enjoy close encounters with Gold Bar number 27. Visitors could place their hands in a display case and touch, handle, and raise the gold bar without removing it. As we've noted during the bar's display in the museum, probably 3 to 4 million visitors picked up the gold bar. So this was part of a nice little exhibit where you could actually touch a real piece of shipwrecked treasure. How cool. So you get to touch this thing and you get to pick it up and lift it. And unfortunately, some other people took the word lift to a different extreme. So, let's read on. This marketing apparently worked better than the museum hoped, because in 1910, Goldman, his name is actually Goldman, that's kind of hilarious, and Johnson drove all the way from West Palm Beach to the museum in Key West. Which, I'm not saying that Palm Beach and Key West are right next door to each other, but all the way? I don't know, man. I mean, whatever. There, Goldman served as a lookout while Johnson wandered around trying to find something to steal. Surveillance video shows Johnson unsuccessfully attempting to pry open several display cases while Goldman stood watch. Eventually, Johnson broke off a piece of the case displaying Gold Bar number 27, and unfortunately, he lifted the gold bar in a way not intended. He and Goldman, the iconic bar number 27 in hand, left the museum and drove to West Palm Beach. And that's where gold bar number 27's luck finally ran out. After stealing the bar, Johnson used the bar as his personal treasure stash, sawing off pieces as needed until just a small piece remained. So very, very sad. So this gold bar has unfortunately come to the end of its life. Apparently they were able to steal the gold bar from the middle of a museum somehow and take it back to home, and they are now like using it as a piggy bank. So they're sawing off pieces, and gold bar 27 is sadly no more. It's very depressing, including for gold bar 27. So, the wanted poster for gold bar 27 is pointless because it is no more. It has ceased to be. So how are we going to make up for all this? Eventually, the law caught up with our miscreants. A grand jury indicted them for conspiracy to commit offenses against the United States in violation of law, and a nice little bonus point, theft of major artwork in violation of law. I like that. I like that very much. So, conspiracy to commit offense against the United States and theft of artwork. I like that. It's just what are we going to get them for? The theft of art. That's cool. Johnson pled guilty to both counts of the indictment. In his factual proffer, Johnson agreed that the bar was worth $556,000. At Goldman's trial, the government presented evidence detailing the history of gold bar number 27 and Goldman's role in stealing it, which we've already noted. It also put on evidence explaining how the government eventually discovered that Goldman and Johnson had been responsible for the theft. Specifically, while attempting to steal the bar, he left a fingerprint on the display case. So they were thoughtful enough to drive from West Palm Beach to the Keys, and thoughtful enough to apparently bring prying instruments to break open the cases. But, they didn't think to wear gloves or something. So he left a fingerprint on the case, which, kind of shows you're there. So that's, pretty important detail. So, could have thought about that, but no. The crime remained unsolved until 2015, when Monroe County Sheriff's Office received an anonymous tip through the TV show Crime Stoppers. The call led investigators to Goldman. That's hilarious. So someone called Crime Stoppers. It actually worked. Someone said, hey, I think this guy stole a gold bar. Goldman's pre-sentencing investigation report valued the stolen gold bar at approximately $556,000, the value the museum placed on it. It noted the victims included the museum and an insurance company, which paid only $100,000 of insurance to the museum for the theft. So the gold bar was insured. And the insurance company paid $100,000, which might suggest the gold bar is worth $100,000, right? So maybe it's not worth as much as has been previously reported. So how much is this? This is where we break into the Pawn Star part of the experience, where we go into Rick and say, let me call in an expert. I have an expert who's an expert on shipwreck treasures and can tell us if this bar is $100,000 or $556,000. So maybe we should have consulted one of Rick's experts, but sadly that was not available, so we'll have to do something else. As relevant to the appeal, the pre-sentencing report recommended that Goldman be responsible for a loss greater than $550,000, which would result in a 14-level enhancement of his charge. So not all thefts are created equal. The more you steal, the more bad it is. And $550,000 is 14 levels of bad. The pre-sentencing investigation report also noted restitution is mandatory and concluded the loss is $556,000, with $456,000 owed to the museum and $100,000 owed to the insurance company. So Johnson objects to the value and how that would impact his sentencing guidelines. So he's like, oh, wait a second. How much I stole goes to how long I have to be in jail. So suddenly I don't think the gold bar is worth $556,000. I think it's only worth $100,000 because I have to go to jail for less long, please. So now we have to figure out how much this gold bar is worth. Okay, so let's do that. In support of objections to the valuation, Johnson submitted insurance documents by the museum, the insurance provider, AXA Art Insurance, detailing how AXA calculated the value of the gold. According to the documents, AXA did not agree with the museum's $696 valuation. It noted asked the museum for information as to how it valued the artifacts, but the museum failed to respond. So the insurance company said, we don't think it's worth that much. How are you coming to that number? And the museum didn't have anything. So the insurance company stated it's valued the gold bar using methods set forth in its policy language, which provides coverage for liability for current market value of property at the time of loss. So we will give you as much money as is valuable. All right. So to calculate what that would be, AXA identified 5 auction shipwreck bars from the ACOCA, which it deemed comparable. So, as always, when you're trying to determine what something is worth, you can look to comparables, right? So it's like, what is a comparable for a gold bar from a shipwrecked treasure? How about other gold bars from other shipwrecked treasures? It's at least a reasonable place to start. So the ACOCA was a fellow ship in this journey and also didn't make it, and also had gold, and also was the bottom of the ocean, and also came up on the market. So we can look at those gold bars and be like, aha, those are comparators. So how much is this gold bar worth based on those gold bars? Okay. So apparently of the 5, AXA relied on 3 that had sold in auction in 2009 to determine what the current market would be. Based on its review of auction prices for 3 bars, AXA determined similar gold bars sell on average for 45% above their melt value. Thus, AXA calculated the melt value to be $63,228.13 based on weight and purity. So in terms of the raw gold that is in this gold bar, apparently, at the time, there's $63,000 of raw gold. But it's not just any raw gold, it's shipwrecked raw gold, so that makes it more valuable. So AXA added 45% of the value because it's shipwrecked, along with 15% because of notoriety and iconic value. Because this just, again, wasn't any shipwreck gold. It was lift a bar shipwreck gold. So we added 45% based on market conditions, and then we added another 15% because it's iconic. So the insurance company came up with the number of $101,165.01. So that's where the insurance company came out. Okay. Melissa Kendrick, the president and CEO of the museum, testified at the time that Gold Bar 27 was stolen. The museum estimated its value at roughly $550,000. She explained the museum arrived at this valuation based on a point system used by Mel Fisher Investor Division. Okay. Every artifact, when it's found, is appraised and given a value. That value is expressed in points. So, for example, this pen in 1985 might be given 100 points. Today, it's still 100 points. But what changes is the valuation of a point. So that would move with the market because the number of points times the point value would give you a fair market value. That's the price the willing buyer and willing seller are able to reach the transaction. So that, to me, doesn't strike me as inherently obvious as the best way to value something. So we're going to say that all art is at some level equal, and we're going to all give them a number of points. And however many points times the current market value of each point is the price of that item. I'm not sure it works that way. No. According to Kendrick, when Gold Bar 27 was recovered, it was assigned a value of 8,178 points, somehow. And multiplying those points by the value of points reached $556,000. This sounds way, way more arbitrary than what the insurance company did. The insurance company at least looked at comparables as best as they were able and found 3 comparables. It's like, well, they sell for price plus 45%. So we'll give you price plus 60% because it's special. And the museum says that's not fair. This is how we value it. How do we value it? Magic. Points that are given at the time it's found and stay the same. Which would imply, because according to her testimony, the points stay constant, even if the value of a point changes. So that means that you have art object A, art object B. When they're discovered, or when they're created, art object A has 100 points. Art object B has 200 points. And because the number of points remains consistent, that will always be true. Which means art object B will always be worth twice as much as art object A, no matter what happens in the future. That doesn't sound plausible. Art object A or art object B might come to renown and be valued and, be desired or not. It's like, I'm not sure that this makes any sense. So the insurance company said, let's look at comparables. The museum said, let's look at magic. Okay, magic, fine. After opining that Gold Bar was worth 27 was worth $556,000 because of numbers we made up, Kendrick recounted that when Gold Bar 27, AXA paid out approximately $100,000. Apparently, they were unable to fight the insurance company with the magic. Although Kendrick acknowledged several other bars recovered from the wrecks had sold for much less than this, she offered a couple reasons. So my bar is really, really special. Really, really special. 5.5 times more special. Okay, Kendrick said the other bars were sold at auctions. Therefore, Kendrick reasons the only thing you can derive from those sales is what a willing buyer and willing seller are prepared to pay. So very close to melt value. I don't even understand what this argument is supposed to mean. Okay, these were sold at auction. And that's bad because what auction tells you is what a willing buyer and a willing seller are willing to pay. And that's bad for determining what the current value of an item is worth. Okay, I don't get that. Second, Kendrick continued, other gold bars did not have the predigy the Gold Bar 27 did. And the stolen bar was iconic, unlike the others, which were ordinary shipwreck bars. She emphasized that during the 30 years Gold Bar 27 was on display, about 3 to 4 million people had touched it, which in Kendrick's opinion had greatly increased the value of the bar, apparently to a 5.5 times multiplier. Kendrick says, quote, yes, but if a bar is bought up from either of those two shipwrecks and they're put in someone's sock drawer, they don't continue to gather value for the story the artifact could tell. If a gold bar belonged to Elvis, and Elvis had that bar and did certain things with it, then that would become part of the story and it would enrich the value of that object. We at the museum enrich the value of the object by putting it on display and having every one of our visitors have the opportunity to interact firsthand with history. So somehow, this is like if it was Elvis's gold bar or something. Okay. Nevertheless, Kendrick conceded that the museum is not in the business of buying and selling gold bars, so you have no knowledge as to what the price would be. Kendrick also admitted they're not aware of a single gold bar from the wrecks that had sold for even half this price. So, there's that. The district court accepted the museum's valuation as proper. So the district court says, I think it's worth $550,000. Okay. The district court says, quote, the thing that troubles me about this particular item is you can find the value by melting it down and selling it for its weight in gold. And that might be what people that are selling it and buying it were doing. But if these were rare books, what are they worth? 12 cents? Yet they're worth $100,000. And I think that someone like that in a museum is entitled to place a value. I think particularly when the parties has agreed the value is $500,000. I'm not going to go below that. Okay. So because rare books are worth not 12 cents but $100,000, therefore this gold bar is worth $550,000. Something about the logic leaves something to be desired on that one. For the record, Goldman objected to the court's determination of the gold bar value. The government then asked the district court whether it would have imposed the same sentence had it not made the determination as to value. The district court said yes. I would have made the same determination because my position is it's a priceless piece of art. A priceless piece of art that's worth $550,000 apparently, but okay. So there's two issues at play here. How much is he going to be sentenced for, and how much money does he have to pay back? So how much time does he have to serve, and what level of restitution does he have to give? So we're going to do those two things separately. Let's start with the how much time does he have to serve part of this equation. Okay, let's read on. We begin with Goldman's sentencing challenge. As we've noted, Goldman objects to the district court's value of Gold Bar 27 that figured in the court's total offense calculation. In particular, under the United States Sentencing Guidelines Manual, it sets forth offense guidelines applicable to the theft of cultural heritage resources, and then imposes an enhancement to the basic level depending on the value of the item. For example, a value of greater than $550,000 but less than $1.5 million results in an enhancement of 14 points, which those points do have a value, unlike the museum's points. But in this case, we do not dwell on whether the district court correctly asserted the value for sentencing purposes because the district court said it would have imposed the same sentence regardless. And under our precedent, we need not review an issue when the district court said it would have imposed the same sentence even absent the error and the sentence is reasonable. This is because under circumstances we've explained, any error in the guideline is harmless. So if the district court doesn't make a reversible error, it doesn't really matter. So district court can make some errors that matter and some errors that don't. So here the district court says, I'm sentencing you to this reason. I'm sentencing you to this term for two reasons. One, because the bar is worth this much. Two, because even if it's not, you did it really, really bad. And the Court of Appeals says, well, even if they screwed up, the bar is worth this much. The district court is the sentencing court, and they're allowed to consider how bad your thing is. So, we don't think they abused discretion by giving you this enhancement. So we don't really care what the bar is worth at this exact moment. That would have been a reason. It would have been a reason for the district court to do this, but they didn't have to do that. They can sentence you to anything within the statutory range, right? The guidelines are guidelines. And the court can say, you did a particular bad. So could the court look at it and be like, yeah, this particular piece of cultural heritage is worth this enhancement because of how much people like it and how much it's in a museum and how you stole from the poor, poor children who now can't touch the bar anymore, you monster. Court of Appeals looks at that and be like, yeah, that would be a valid reason. So, enjoy your additional time in jail. So sucks to be you. But then there's the question of restitution. How much money does he have to pay back? So after he's done serving his enhanced time in jail, how much money is he on the hook for? Let's read more about that. So apparently it was worth additional 13 months. So it's worth an additional year. So he served 40 months instead of 27. So, lame. Still lame. A district court may order restitution only as the statute authorizes. The relevant law requires the district court to grant restitution to all victims once the defendant is convicted of any offense in which an identifiable victim or victims has suffered a monetary loss. We have said the primary and overarching purpose of the relevant law is to make crime victims whole, to fully compensate them for victims of their loss, and restore those victims to their original state of well-being. Restitution should not provide a windfall, nor is restitution intended to punish the defendant, for which, there's jail. We're not punishing you by saying, give us the money back, because it wasn't yours. We're punishing you by putting you in jail. Also give us the money back. For these reasons, the restitution award must be based on the amount actually cost. When, as here, the return of property is impossible, the relevant law states the defendant shall pay an amount equal to the greater of the value of the property on the date of damage, loss, or destruction, or the value of the property on the date of sentencing, minus any value of the property returned. So, if it was worth more the day you stole it or more the day you sentenced, either way, plus anything or minus anything you give back, and you must determine that value by preponderance of the evidence. When loss involves a unique item for which no ready market exists, fair market value may not necessarily be an option. So we've explained that what actual cost value is unavailable or unreliable. We determine value under the relevant law by looking at replacement cost. Replacement cost is the cost of a substitute asset that's essentially equivalent to the asset currently held. We have no precedent that directly articulates how a court should determine the value of a unique item stolen from the museum, but the relevant law does provide instructive tests. For the purposes of ascertaining the best way to establish value under the relevant law, artifacts like gold bar number 27 are roughly analogous to unique items lost in prior cases. Like special aspects of a church and sacred ground, gold bar number 27 unique property render its actual cash value unreliable and unavailable. So it makes sense to treat gold bar number 27 like a church and like sacred lands the same way for the purpose of valuing them. For that reason, we reaffirm our holding that where, because of the unique nature of an item, cash value does not sufficiently compensate under the relevant law for loss, a district court should use replacement value to determine restitution. A district court must explain how it arrives at its loss figure so we can conduct review of that determination and ensure it's based on sufficient evidence. Unfortunately, in this case, we're not able to do that. We do know the district court rejected the idea of valuing gold bar 27 based on auction prices of other gold bars discovered in the wrecks of the similar wrecks. We also know the court identified gold bar 27 to be $556,000 based on Kendrick's testimony, who is the museum person that's worth that amount. Indeed, the court explained that something like this in a museum is entitled to place a value on it. By allowing Kendrick, the museum person, to put the value on it, absent any evidence of her own training or any explanation of the point system, is not appropriate. She can't say how much it's worth objectively. So, no. And here the record contains no explanation of how the Mel Fisher investor dividend point system works, because it's magic, on which the museum blindly bases its valuation. Silence in this situation is not golden. Ha 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 ha. We have no idea, for instance, what the purpose of the Mel-Fisher investment dividend point system is. In the absence of any evidence establishing a basis for the Mel-Fisher investment dividend point system, we cannot evaluate whether the district court's valuation based on the system was a reasonable estimate of replacement costs of gold bar 27. For that reason, we vacate the order of restitution and remand the district court to conduct an evidentiary hearing to determine a reasonable estimate for gold bar number 27. So give it another shot. Perhaps the government will be able to put on evidence to establish the reliability of the Mel-Fisher investment division point system. Perhaps not. I'm thinking not, because it sounds like made-up magic. Or perhaps AXA's valuation better establishes replacement value. Its components appear to account for what would seem all the necessary considerations. Melt value, based on the sales of comparable bars, a premium for the fact gold bar 27 was retrieved for the Santa Margarita, a premium for the fact the iconic bar lift bar exhibit. But the record contains no indication of how AXA arrived at the 15% premium for the lift bar status. So we do not know whether the 15% premium is reasonable. We must consider these questions in the first instance. So that brings us to the end of the case of United States of America versus Jared Alexander Goldman. In this case, Mr. Goldman stole a gold bar, true to his name. And the gold bar might be worth $60,000 or $100,000 or $556,000. No one is quite sure. So we know two things. First of all, he has to serve an extra year in jail because the judge thought he did an extra bad. So he has to serve an extra year in jail. So that's very, very sad. And we also learned that based on the theft that we need to go back and reevaluate how much it was at the time. So we need to go back and reevaluate how much they've given our shot on the value. And that brings us to the end of the story of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.